Alpena probate judge. So, opening statements. First, we will, Mr. LaCross, please.
Certainly thanks to the league for years and years and years of providing these opportunities for us to educate ourselves and inform our vote. And that's very important. To see so many people here is great. There are three things that I want you to remember, and I'll talk fast because I don't have much time. One is under the heading of the past is the best predictor of the future. If you look at my brochure, you'll see 34 years of involvement. My past. Now, is that a good predictor of the future, of what you'll get? Yes, it is. And so there's 34 years, 12 years as judge, but many more years before that of involvement in this community. I've been involved in many, many things, many boards, many projects, so there is that. I'm on the ballot. My name is on the ballot, but it's all about us. We are the ones being elected. We, our values, our family values, our desire to do public service. It's like preaching to the choir here because you know that. They're your values, that's why you're here. The third thing I would like to say is trends. What we do in court is we learn. I've seen for the past 4 years every single crime that's been committed in the county of Alpena. I know those trends. I go outside the court to create programs to prevent those crimes and other things. Thank you.
Ms. Burke.
Thank you. I'm an attorney here in Alpena, and I've been practicing for 26 years. I've had my own private practice for 23 years here in Alpena. Can you hear me? Now, better now. So 26 years practicing law, 23 here in Alpena in my own private practice. I've spent my life to get to this point. My dad was a district judge for 25 years. I went to court with him as a little child and was amazed and observing him work, and I learned a lot from that. I went to University of Michigan and got my degree in public administration because I wanted to serve. I knew I would serve someday. And then I went to law school at Detroit College of Law, which is now Michigan State Law School, and I got my degree. While I was in law school, I worked for a public guardian in Alpena, or in Wayne County. I went to nursing homes. I visited people in Wayne County. I did all the pleadings for the probate attorney, and I learned a lot from that. I worked at prosecutors' offices, and I learned a lot of working with victims and in that area. I've worked for a judge as a law clerk, and then my own private practice. I've listened to people, I've helped people, I've tried to figure out what can keep them away from crime and what can help them lead successful lives. So I've prepared my whole life for this moment, and I'm prepared to be your next judge. Thank you.
Thank you. We will start the first questioning with Ms. Burke. What do you consider to be your judicial philosophy?
My judicial philosophy is right here. It's the Michigan Code of Judicial Conduct. That philosophy is to be impartial, not to use any of our personal biases, not to use any of the things that we think are right and wrong, but to be impartial. That means to follow the law, apply the facts with the law, and have a fair decision. We're not to let any personal bias of our family, our personal views into that courtroom. And that's my philosophy, is that we should promote public confidence in our judges by treating everyone with respect. That means whoever you are treated with equal respect as anybody else. Not to be yelled at, not to be screamed at, not to be treated poorly. And to treat everybody equal and a fair determination, not preconceived when you come into the courtroom that you already made a decision that you're guilty or you're innocent, or I don't like what you did or I liked what you did, but fair and impartial, listen, apply the law, and respect the judicial code of conduct. That's my philosophy.
Thank you. Mr. LaCross?
Yeah. Certainly, my judicial philosophy has a lot to do with respect of the individual. Not only of the individual litigants, but also of the public. We have to respect all of the public, whether they're in court or you folks, okay? There's a presumption of innocence until proven guilty in criminal cases. And so the justice is blind to all those individuals until they've been found guilty or have pled guilty. Then the elevation of your public safety becomes most important relative to that person. And as I said in my opening, the past is the best predictor of the future. What does that person's past say about their future and putting you at risk and responding to that, okay? And so judicial philosophy is certainly the canons and the law, but the law looks at every citizen and is very transparent and open and is involved in respect. You know, allowing respect and truth. That's most important. That's the judicial philosophy. That's a philosophy of life. So.
Excuse me, back here where this motor is running, people cannot hear without speaking into the mic.
If you will,
I'm sorry.
pull up your mics a little closer. Thanks.
Thank you.
Mr. LaCross,
Yeah.
there seems to be an increase in mental health issues today. What findings would you need before having a person committed for hospital care?
Yeah. Certainly the burden of proof is clear and convincing evidence, right? And that's more than a preponderance, it's less than reasonable doubt. I listen to all the evidence and then make a determination as to what level of treatment a person needs for their particular mental illness. Some people need involuntary hospitalization. That's pretty darn serious stuff. Some people need less than that. And I think that we see increases in mental health for a couple of reasons. One is because we do a better job at assessing when mental health is being impaired. Okay? The other thing is that what impacts and makes mental health worse is the influence of the use of drugs, illicit drugs, not prescription drugs, not psychotropic drugs, but other drugs that people use, and they render sometimes their psychotropic drugs that are prescribed by psychiatrists ineffective. And so you see their mental health deteriorate. And that's those couple of things, better assessment and the influence of drug abuse on those individuals.
Thank you. Ms. Burke?
Yes, can you read that one more time?
Sure. There seems to be an increase in mental health issues today. What findings would you need before having a person committed for hospital care?
In regard to mental health issues and hospital care, kind of two different issues, but you have to listen, as Mr. LaCross said, you listen to the facts and the evidence. Typically, you're going to have community therapists there, take their input. You're going to have a doctor's input. You're going to have their family input, and you should have the patient's input. And if you listen to all the information, you will be able to make a right decision on whether or not someone should be hospitalized or not. But on the mental health issues, it's huge. And I would like to see, some of the counties have done mental health court, and I think we need to do that in our county. We have drug court, but we don't have mental health court. Drug court in the state of Michigan, we have 3 pages of courts that have that in Michigan. Mental health court, we have a little over half a page. More courts need to institute a mental health court so we can address all the needs of the mental health issues. As many of you have seen in the paper, we had 2 articles recently. One, illness is illness. talking about how much mental illness we have in our communities now. There's anxiety, there's all different other types of mental health issues. And then you have the schools that says it's okay to say. And the schools are working on that. We in the court system need to institute a mental health court. Thank you.
Thank you. Ms. Burke, could you comment on elder abuse in Alpena and other areas?
Yes. Elder abuse, I'm very passionate about. I have actually elderly parents that I spend a lot of time with, and my mother-in-law. I've been to lots of nursing homes before. I've seen lots of videos of things that have happened. I've seen people take advantage of the elderly. A lot of the elderly don't have advocates for them. They don't have family in the area. And there are a lot of people that take advantage of them. I know recently, even with my mother, we had an agency come in to help take care of her, and the worker was trying to get money from her and to have her buy her things. It happens everywhere, every day. We don't have advocates for the elderly when they have to go in here to hospitals and to other organizations. I would like to see some sort of group start so every elderly person has an advocate for them. They have an advocate for them in the nursing home. They have an advocate for them at the hospital. They have an advocate for them in the courtroom. Every long step of the way, they have someone to help them. Because elder abuse is huge because we don't have families with everybody. People are living longer. They don't have husbands and wives. They don't have children that are in the area because jobs take us outside of our own community now. And it's dear and near to me to see that people are taken advantage of. Thank you.
Thank you. Mr. LaCross?
Yeah. With regard to elder abuse, it goes right to the heart of the definition of probate court. Probate court is all about protecting the vulnerable. That's the highest priority of probate court. Not only elders, but cognitively impaired people, disabled individuals. There's all kinds of issues that make a person vulnerable, okay? Age is one of those things that may make a person vulnerable. It's not automatic. And what we have done is we've had several meetings with several banks, for instance, to talk about what they see as being a challenge to elderly people. And yes, we've had in this area where an elderly person will go to the bank with another individual and take out large sums of money and basically turn over that money to the individual. And so the banks they're challenged because there are rules of privacy that protect that, and yet those tellers know that the person is being taken advantage of. There are all kinds of issues like that, and we can't be asleep at the wheel. We have to be very cognizant and aware of all those issues that challenge us. And at the same time, respect self-determination, decision-making of people who can make decisions. So it's a fine line there, and we have to show respect again.
Thank you. This question is also for you, Mr. LaCross. How could the courts handle cases in a more timely manner?
Yeah, I'm all over that issue. And I work with the State Court Administrative Office and all courts. And the State Court Administrative Office is in charge of all trial courts in the state. They have well over 100 people, full-time employees, that do that to make our courts more efficient. And I work with them all the time. What I brought today are 2017 performance measures, and this book is all data that we work with, and it's just the Alpena courts. This book is just the Alpena courts. There is a book like that for every court, so the analysis is constant. We have 13 people working in our county, 29,000 people or thereabouts, working on making your courts more efficient. And we just did our satisfaction surveys, and my administrator did the district court and looked at all the surveys, anonymous, Not one was dissatisfied. Everybody was taken care of. Can we improve? Of course. We always improve. Are we better than we were last year? Yes. Are we better than we were the year before? Yes. Will next year be better than this year? Yes. I can guarantee that.
Thank you. Ms. Burke?
Can you read the question one more time?
How could the courts handle cases in a more timely manner?
A lot of people don't know, the state court administrator dictates to all the courts to have things handled in a timely manner. They require the judges to do that. They keep track of that. They encourage the judges to get things over. There's time constraints on them. So those time constraints that are put on the judges are therefore put down in the court to the attorneys, to the litigants, whoever it is, to move things along. And the reason they want to do that is because anybody that's been part of the court system, your matter's the most important thing to you, and you want it handled as soon as possible because it causes anxiety and stress on the individual. So it's already in place to have things handled smoothly. Everybody's required to do that. What I would say what the judge can do to help that is to make your decisions timely and fast, not take things under review for long periods of time, and be accessible to your cases. That means you are there and ready to handle those cases every day, and you're prepared. You're ready to go when that case is handled. You give it your utmost attention, and you make your decision in a timely, considerate manner. Thank you.
Thank you. Next question, Ms. Burke. Why doesn't Michigan require background checks on court-appointed guardians like other states do?
Well, we can't do everything. You can't have a law for everything. But it would make sense that we would do background checks on our court-appointed guardian and conservative. We should. We should, before we hire someone to have in our court to take care of our elderly or the people that cannot make decisions for themselves, we should do a background check. Now, just because you do a background check, someone might have had something 30 years ago, and it may or may not be important, but we should certainly know. We should know what's there, and we should consider that before you hire someone and send them out to work with our disadvantaged or people that can't make decisions for themselves. And I think we should have background checks. I do background checks all the time, and anything that I have to research, any client, I look at everything in their past so I can help them better. And our employees that we hire and send out there, we should know.
Thank you. Mr. LaCross?
Yeah, the state doesn't necessarily require it, but I do. Okay, we do background checks. And background checks are various levels, okay? TSA worker has a pretty extensive background check, and less so for different workers, okay? We do a background check on people who petition, who suggest themselves as being guardians. Now, there are two types of guardians and fiduciaries. There are professional fiduciaries, and there are family members that are just a fiduciary or a guardian on their particular family member, and that's fine. But part of our process is to do that check to see that that person, that's not required by state law, that's right, but I require it because I want to know that the fiduciary is going to be appropriate and guard that and protect that person, okay? So.
Thank you. Next question, Mr. LaCross. What are the biggest challenges that a judge faces in probate court?
Certainly in probate court, it goes back to the definition of probate court, to protect the vulnerable. That's what we do. Now, a judge's job is 24/7. I don't go home at night and not think of the individuals. Of course I think of the individuals and the challenges they face and the people that are in charge of taking care of them. I've had run-ins with different entities, different individuals, because I perceived they were not protecting the person enough. I had questions, and it's my right
to protect them and to ask those questions to make sure their rights are protected. Is it perfect? No. Does it happen? Yes. Technically, the judge is the first guardian, the first fiduciary of every person. And then the judge delegates to others to take that job, okay? And is the court's agent. So I have to trust who that person is to do and to work with everybody to take care of that vulnerable person. Okay, so it's something that is, like I said, 24/7. I think about the people that are in our court all the time.
Thank you.
You want to read it one more time?
Sure. What are the biggest challenges that a judge faces in probate court?
I think the biggest challenge that the judge faces in any court, including probate court, is that we have to meet the needs of our community. We're here to serve the community. That's what we do. And we have to meet those needs. One of the needs that I've found in this community, as any community, is you have to be able, people don't understand what's happening to them. They don't understand the law, they don't understand the system, they don't understand what's happening to them. You have to have the ability to explain it so they can understand. And that might be saying it thousands of different ways so they can understand. One thing also is a lot of times we don't get all the information that we should have. For crime victims, there's something that's called the Crime Victims' Rights Act, where crime victims can give their point of view, what they want to see happen, what their concerns are. Why don't we do that in probate court? Why aren't we sending out something to the community to say, what are your needs being met? Is there something that we can do better? The other thing that I've had lots of complaints about is accessibility of the courts and understanding what the forms are and what to do. And I think that we can do literature to help people understand what the process is, what the steps are, and how they may be able to help themselves within the court system. Thank you.
Thank you. Next question. Actually, this will be our last question. And I'll start with you, Ms. Burke. Will you protect developmentally disabled? Their rights are so very important. How would you protect their rights?
Absolutely, they are very important. One of my first cases when I came to Alpena was a Down syndrome child that was being charged with a crime, had no mental capacity at all to even understand what they did wrong. And I've worked with a lot of mentally ill and disadvantaged youth and adults. And I think that we need, again, to make sure that their rights are protected by reaching out to family, therapists, to community mental health, the people that work with them, so we can truly understand their needs and make sure their needs are being met. And I don't think we do that a lot in the court system. We don't reach out to truly understand a case by getting documents from all different people, information from all different people, and then deciding what needs are of that individual that's before the court. And for the mentally ill and the handicapped and the mentally challenged children and adults, I think that we need to do better at making sure that their needs are being met and no one's taking advantage of them. And we can do that with an advocate for each person. Thank you.
Thank you. Mr. LaCross?
Sure, there is an advocate for a developmentally disabled individual. They're automatically given an attorney for their hearings. Also, we do a 5-year assessment, a reassessment of every developmentally disabled individual. They go to community mental health and they're retested, and I require that the master's level person who did the assessment comes into court and testifies as to the level of their need. And so we are very aware every 5 years of a person's circumstance. And as the need arises, they can come into court, or family, any interested party can come into court and let us know what's certainly going on. Now, again, an analysis of my brochure indicates that my function is not just in the court. It is, I can't tell you how many meetings I've had at community mental health and with different therapists and with different people to educate them, to be educated as to what's going on in the field, to take care of developmentally disabled people. And there should be no misunderstanding. Developmentally disabled people are not necessarily mentally ill, okay? That's a different circumstance. Developmentally disabled people are developmentally disabled. Mental illness oftentimes is totally different. So to mix those up is not appropriate at all. And that really confuses things and gives people a label that they don't deserve. Developmentally disabled people are people that are entitled to be protected and taken care of by their family and by us.